Hey guys, it's Kathy. I hope you're doing well. Finally, man, that countdown is the worst. Waiting to press go live, waiting and waiting. But I want to make sure that everybody has a chance to get in here. All right, we're going to start with the new judge today. We're going to start with not the new judge anymore. Um, but I got to tell you, I got New Jersey. And I'm so excited that I got New Jersey because, I would really love to get New York. I mean, imagine the courthouses in New York. They must be crazy. But, there's none. Zero, zero that I can find. But yesterday I found like four courts in New Jersey. Not New York, but close enough. And it did not disappoint. Really didn't. And then I found another judge who must like sit like right next to Judge Fleischer. Their courtrooms look identical. They're both from Harris. Um, and I don't have his clip today, but he's so boring. He's so boring. He is just not Judge Fleischer at all. But I'm going to get one of his clips for tomorrow if I can, and we can compare. That if you get busted in Harris County, you're either going to get this judge or you're going to get Judge Fleischer. Oh, man. All right. And then we go through uh, this poor judge in Indiana. We'll end with him. He has a day with this guy. He really does. But, he just keeps rereading his stuff over and over. All right. Let's go light him up. He's going to light him up.
Skip that one. Page 2, Betancourt.
Mario Betancourt. Was that you? Come on. Do you have a lawyer today?
I do not.
Tell me what you're doing about that.
I was trying to do my best to hire a lawyer, but I couldn't afford one.
How many did you speak to?
4.
That's not enough. I mean, you got to speak to more than 4. There's a gajillion lawyers out there. If you pay a couple $100 a month, they'll represent you. What do you do for a living?
I work at Amazon.
Doing what?
Project manager.
How much money do you make a month?
Not project manager, sorry. I do stolen stuff. Like
How much money do you make a month?
a month, 1,000.
Just 1,000. Who do you live with?
I live with my wife.
What does your wife do?
She's a project manager for a company, and she's an officer of the company.
How much money does she make a month?
We don't talk about that. Me and her.
To qualify for an appointed lawyer, you have to be at the federal poverty guideline. Okay, we just don't give them out. You have to actually qualify for a lawyer. So if you wanted to apply, I would need to know how much household income both of you guys make. So if you want, I can send you home with an application. You can speak about it with her, but I need a truthful application of what you make a month, what she makes a month, how much money you have in a bank, stocks, bonds, IRAs, mutual funds, what kind of cars you drive. I need to know everything about you before you even try to apply for an appointed lawyer. You understand? Your other way is to hire a lawyer, and I'm telling you, there are a gajillion lawyers. It's a matter of you finding one that you can afford, negotiate with them. 99% will put you on a payment plan where if you pay a couple $100 a month, they'll represent you. Do you understand?
It's a,
Do you mind running his license to see if he has a license? Do you have a Texas driver license? The other thing is this, is that because you have a DWI, you also have a case versus DPS. If you don't request an administrative hearing within a certain amount of time, your license gets suspended. You probably have not done that, have you? So your license is going to be suspended 40 days after the expiration of 14 from the day that you were arrested.
He's not.
So you're not allowed to drive. Your license has now been suspended. Do you understand that?
it's a,
Okay, I'm gonna have you sign with me today an affidavit promising me you're not gonna drive. If you drove here, you may not drive home. Do you understand?
Yes, sir.
All right, I'll have you come up here, swear to this. We will give you an application, take it home, fill it out. In the interim, I would also start talking to other lawyers to see what you can do. But as far as I'm concerned now, you cannot drive whatsoever. If you drive, you will go to jail. Do you understand?
Sir.
Please.
All right, Judge, we're circling back to an arraignment, bottom of page 2.
Okay.
Okay? Come on up.
Are you Mr. Boca Negra or Boca Negra? Negra. So you're charged with terroristic threat of a family or household member. That allegation kicks it up to a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir. See, not on. Here we go.
Showing up is already a thing.
Victoria, I don't understand how he has Miss Hayes already.
He was in custody and he was let out over the weekend. His bond paperwork says for 12, but he came in today.
Got it. Okay. So let's figure out, do you mind going for?
Yes.
Yeah, PC, please. Yes, please.
On February 3rd, 2024, in Harris County, Texas, officers dispatched to a terroristic threat call. Complaining witness stated she broke up with defendant and he called her, asking her about if she was going to date other people and told her, quote, "Don't make me come over and shoot the house up," end quote, and told her he would be over in 15 minutes. Complaining witness was in fear for her safety and told officers defendant showed up before they got to the house and defendant left when she told him she called the cops. Complaining witness stated she knows the defendant has a gun and keys to the house still and has hit her in the past, so she feels he would carry out his threats. Complaining witness told officers defendant has pointed a gun at her in the past and threatened to kill her. They have a 3-year-old daughter together.
Mr. Betancourt, I'm going to find that there's probable cause to go forward. I'm now issuing a protective order and ordering you not to have any contact with this person whatsoever. Do you understand? No contact means no contact, any means. I don't care what your smoke signal, social media, email, phone calls, text messages, no means no. I'm also ordering you not to be in possession of any weapons as well. You violate these conditions, I'm going to yank that PR bond in a heartbeat.
Sir.
Do you mind filing that, guys, please, to no contact, no weapons? It's your responsibility to stay in touch with the lawyer that we've given you. If she comes back to me, tells me she can't get a hold of you because you're playing games, you're not responding to phone calls, text messages, like, I will also revoke your bond as well. Understand? I'm gonna have you go to Victoria, sign a reset. After that, we'll have you take a seat in the jury box while we wait for your bond condition. We'll have you sign it, and then we'll have you wait for your lawyer as well. Please.
Es el intérprete. Parece aquí en el centro. Solo mire el juez y le contesta nada más en español, por favor. La próxima vez se abrocha en la camisa. No se esconde sus cadenas.
Mr. Rivera, do you have a lawyer
¿Rivera
today?
tiene abogado el día de hoy, señor?
No, es que no he tenido un trabajo para agarrar.
Mírenlo solo a eso. No, I just haven't had enough employment to hire one.
How do you support
¿Cómo se
yourself?
mantiene usted?
Del trabajo. Trabajo es que tengo como 15 días por un mes que no he trabajado.
Sure. I work just in the last 2 weeks to a month, I haven't been able to work steady.
How are you surviving then?
¿Cómo está sobreviviendo ahora?
Por parte de mi señora,
Okay. My wife is helping me.
Does your wife do
¿A
full?
qué se dedica su esposa?
cuida viejitos.
She takes care of the elderly.
You want to apply for an appointed lawyer, sir?
¿Quieres solicitar un abogado de oficio, señor?
Sí,
Yes,
Thank you.
por favor. Llene todo, no deje nada en blanco. Está en inglés y en español. Okay? Is there a pen there? Yes.
el problema es que no sé leer.
No sé cómo le va a hacer. Salga afuera y que alguien le ayude por teléfono.
Gracias.
Yeah.
You tell him if he can't do it, we can just send him home and he can do it at home. He can bring it back another day. I have to give you a cause number because I don't think we put it on for today, unfortunately. It is. Damn it, I just lost it.
248-9297. All of these, Judge, are he's caretaking for his grandmother, so he's been going back and forth to her house. So I see that a couple of times it's, well, 4 or 5 times it's been late. So that's what we're.
Very late.
This is a DVD case,
Yes.
so do you want to have me call the DVD person down?
This is here written
Okay.
down for this, yeah.
That's fine.
I have, unless you have a really good explanation, I have a couple where we're doing it 2:45 in the morning. So unless you can prove to me something good, you stay with me. Correct.
I was just basically getting something to eat.
I'm revoking your bond and I'm putting you into custody now then, sir. He goes with you.
Oh,
Judge, can we get a bond set?
5,001. It's at 3,000 now. I'll sit at 5,001. Hey,
Good morning, Judge.
we have yet another positive UA.
Okay.
I'm putting an ankle monitor on you, Ms. Jacobo. Listen to me. And if you ever test positive again, I'm going to amend your conditions to put you into an inpatient rehab facility. Do you understand me? Because it tells me that you can't stop, and I'm going to do everything in my power to make you stop. You will now be responsible for the ankle monitor. You have 3 days to get it. Do you understand? This is the last chance you have to remain out of custody. So the next time you drink something that has alcohol, it better be the best damn drink of your life because it's going to cost you 9 months of your life. Thanks.
Just have a seat and we'll get the orders. Okay, have a seat.
I want to talk to the other gentleman. Come up, sir. It's okay. I called him up. Victoria, what was his last name again?
White.
Mr. White, do you have a lawyer today? Who is it?
Carl Moore.
Okay, just go ahead, take a seat. We'll wait for him to come. Thanks. Carl Moore. Hi, Carl Moore. Get ready. Here, I'm gonna light this dude up. Come up, Mr. Gomez. Here yet again with another case. You're now charged with another gun case. You're facing a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you.
On April 1st, 2024, officer observed a vehicle in Harris County, Texas, leaving, driving on the shoulder and on the Gore area. Vehicle then made an abrupt stop on the shoulder, almost striking the concrete barrier wall. Officer conducted a traffic stop. Officer smelled an odor of marijuana coming from the vehicle. Officer removed defendant and the passenger. Defendant was detained. Officer located the black bag that was at the feet of the passenger that contained a Taurus 9mm handgun. The handgun was confirmed to be stolen. Officer also found an AR pistol in the rear seat.
He wasn't driving, was he? Was he driving? Gomez.
Was driving.
Another one that can't stop or won't stop picking up criminal cases.
He was the driver.
Driving on the median, on a shoulder, nearly hitting someone.
Hitting the barrier, almost hitting the barrier concrete wall.
Mr. Gomez, I'm going to find that there's probable cause to go forward with your case. I am now going to make you and me one. You're going to have such a miserable experience. Now you're going to think that it's a new job for you. I am now ordering you to come here and take a drug test every Monday and Thursday for the remaining of this case. I'm also ordering you not to consume alcohol or illegal drugs. I'm going to test you every Monday and Thursday. The one time you test positive, I'm going to keep you with me. And what I'm going to do is I'm going to put you in a rehab facility. Do you understand? Do you have a Texas driver license? I'm going to have you sign this affidavit promising me that you're not going to drive. And if I catch you driving, I will have a contempt hearing. You will be facing an additional 6 months of jail and a $500 fine every time you get in a car and drive. Likewise, I'm going to have you promise me that you're not to have a weapon on this. And if I catch you with one, you'll be facing another contempt action, 6 months in jail every time you either drive or in possession of a gun. Do you understand? One way or the other, we're going to get to you somehow for you to stop picking up criminal cases. And if that means bringing you here every other day to court so that you realize that you need to stop, then that's what we're going to do. I have several children that just can't stop picking up criminal cases. The idea is to make it so miserable that you hate me and you hate the court so much that you start having second thoughts anytime you're going to do something that breaks the law. If you don't get it, I'm going to beat it into you. Jeremiah, every Monday and Thursday he comes to test. Yes. No drugs, no alcohol. On one ankle, I'm going to put a GPS monitor and I'm giving him a curfew of 7 p.m. to 7 a.m. On the other ankle, he's going to get a scram so that we know he's not consuming alcohol. You think it's bad now? Just wait, Mr. Gomez.
How many days was it granted?
3. Waive the fee, please. Can you give him an application for a lawyer, please? Hi, Trinidad. How are you, man? Yeah, of course. Come on up.
Have Ahmad Khalil on the docket. He has a orange sheet too. He's a little.
Back there. You want to have him evaluated?
I mean, it's
Can you communicate
got
or
an
no?
orange sheet from the last time he was in, so schizophrenic.
Are you able to communicate with him or not?
Yeah, I mean, it's difficult, but I mean, he wants to plead, but he also wants to post a bond, so he has $200.
Oh, I remember Mr. Khalil. I remember him.
Apple, head, little grocery shop owner.
We've had a lot of dealings with him.
Has the witness. I mean, his own father's the witness. So I think he's, like I said, a little touched. One of the employees went to go get food, brought it back. He was putting that food up, and that's when he goes off. He comes out from the house, goes off on the CW, and throws an apple and hits him in the back of the head. So,
Who is it? Is it the dad, the CW, or who?
no,
Who's the
it's
CW?
an employee of the little store. And Pops told that employee, go get some, go get some, whatever, fill up the shelf. Or stocking the shelves, when the youngster comes out and goes nuts.
Out of nowhere.
I don't know, so I don't know.
So I think that we should definitely have him evaluated to see. Let's have him evaluated for sure.
And I want to see if I can get a PR bond. It's only $100 bond each, so.
Let's see why they didn't. I'm going to read to you what the magistrate said. Let's see. So it says here, DWI 11-16-23, eligible for GOB, but refused to both pretrial services and PD, told PD wants to be housed to get some medication.
So there's all the things that ain't connected. There's some things going on, just in those few little words, I mean.
I need to know before we just give him a blind PR box that he has a place to go to and he has a place to stay. I don't want to just let him out and then he ends up on the street in more trouble.
So we pull them out.
Yeah. Do you mind bringing out Mr. Khalil, please? Khalil. The last time.
This weekend? Well, I have a trial tomorrow. 8 o'clock. So from. Sure. It's pretty good.
What is defensive declaration?
Well, I have two.
So, hey, we just did a report on him in January of this year. And he was found competent to stand trial because he just pled to the DWI.
He just plead. I don't think he understands the ramifications of shit. He just wants to plead and set a bond at the same time right now. There's a mental health issue.
I'm gonna print this for you. I'm gonna print this for you so you can read it because this is just from.
Yeah, for our benefit, to protect everybody here.
Mr. Khalil,
Good morning.
what's going on with you? Do you have a place to go to if we let you out?
The homeless shelter.
What about mom and pop?
I have to wait until they, or until my mom gets another place.
Do you have a number that we can call her?
Yes,
What's the number?
713
Okay.
837683.
What about your dad? Do you have a number for him? What is it, please?
281-932-9943.
Okay, so what I want to do is we're going to try to reach out to them to see if they will take you.
I have another number for my dad.
Okay, what is it?
713-782-2277.
Before I give you a PR bond, I want to know that you have somewhere to go. So one more question. Is there any medication that you're supposed to be taking, Mr. Khalil? Have you been taking it?
I took a pill yesterday,
Okay.
You know?
Respridol.
Okay, you have to continue to take it. You can't stop. Bad things happen when you stop. I know you feel good and you end up saying, well, I don't need this anymore. I feel great, but that's when things start spiraling. So please, if they ask you to take it, just continue to take it because good things happen when you do. All right?
Okay.
We'll put you back for the moment. We're going to try to reach out to your folks and then we'll go from there. Okay? Thanks. Just let me know.
Yeah. I'm just doing that.
No, I don't. Yeah.
We'll plug them back here tomorrow. Yeah. Yeah. we should do USB-C. They leave like today. Yeah. Yeah. That's true. I'm gonna keep my iPhone working, so I can't. Maybe she can wear it.
You ready? Tell me.
On Stacy Okagore, she's on docket today. I was just appointing her. I want to do a motion for competency.
Is it Obrador?
OGOGO.
Okay, I guess she's in custody because I don't see it. Okay. Yeah, whatever you need, you got. Okay, here. Are you able to communicate with her or no? No? Okay. Do we need ORs still or no? Do we need the OR?
No, we don't do that anymore.
No? Okay. We usually do a 30-day setting, I think. Right?
30 days.
Yeah, and then I'm okay. If you can get it quicker, wonderful. For sure. If there's anything we can do to hasten it up, just let us know. Sure. Sorry, I had a good court time. I'm just rushing. How are you?
Mr. Floyd Fernandez.
You said Fuentes?
Fernandez.
Fernandez. Thank you. Okay. So are we doing time, sir?
Yes, Judge.
Okay. All right, good morning, Mr. Fernandez. You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement where they're offering you 3 days in jail. We're going to give you credit for the 2 days that you've done. Understand that this charge will go on your record. It's going to be there for the rest of your natural born life. I hope that you realize this, because if you ever smell like alcohol or dope, the first thing an officer does is they're going to look up your record. They're going to see a prior DWI. Do you think they're going to be nice to you if you smell like alcohol? Good answer. They're not going to. You will go right to jail. And what we're doing today, it's not going to happen again. From now on, you're facing a minimum of 30 days in jail. Do you understand? So if you want to get lit, call Mr. Rushing to take you home, because it's not going to happen again. I'm also now going to suspend your license for 90 days, sir. Don't drive until you get a license. Otherwise, you'll be right back with us with a suspended license. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront, cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this, we're done forever. Do you understand? You still want to do this?
You want to go forward with the plea?
Yes.
How do you plead to the offense, sir? I will find you guilty. I'm assuming that they're going to dismiss upstairs.
Yes, Judge.
Anytime you get a felony dismissed, you're working a good day. Don't get caught up here again. Good luck to you, sir.
Thank you,
Thanks.
Judge.
Approaching on last name VILLANUEVA. This was a compliance setting hearing. My client has obtained a portable device, provided proof to the court, provided proof to me that he
I
has.
haven't seen it. You've seen it?
I've seen it in.
You good? Okay, good. I trust you. As long as he's got it, we're good.
Yes. And so
Please tell him,
he's here, he's present.
come up. You will be given no more latitude. The next time you fail me for whatever reason, you will go to jail. You understand?
Okay.
Please stay in contact with her. She will tell you if and when you have to come back to court. If she comes back to me, tells me she can't get a hold of you, I will issue a warrant. You will not get any more PR bonds. You understand?
Okay.
Okay?
Thank you.
Thanks. Ándale. I saw a great show last night. You guys have Disney Plus? A small light. Wonderful. Had me in tears. Gotta check it out.
History. It's got 100% of Rotten Tomatoes.
It's killer. Yeah, check it out. Small light.
Small light.
Set for arraignment, fell to appear.
There we go. He left us off on a heartwarming note. I haven't seen A Small Light yet, so I don't know if it's good or bad. But if he says it's good, then it's good, because I don't want to go to jail. You know, I don't know. He doesn't say terrible things to these people. You're going to go to jail. It's just the way he says it. If someone spoke to me like that, my Lord, nobody speaks to me like that, sir. That judge is great. And if you weren't here at the beginning, I found another courtroom in Harris County that, I mean, it's exactly identical to this courtroom, so it's probably like right next door to this guy. And the judge there is so boring. It's so funny. You can just imagine what Judge Fleischer would say when this guy's talking. It's like, no, you just missed a golden opportunity to light him up. All right, let's go to New Jersey, guys. We got a courtroom in New Jersey. Here we go. Yeah, here we go.
Address State versus Kamani Wilson. Under complaint warrant 2024-245-1514, the defendant previously had their first appearance that is required at this time. The defendant also previously confirmed that they observed the video on or about March 30th of 2024. May I have the appearance of counsel, please?
Thank you, Your Honor. Lenny Domestas, Assistant Prosecutor on behalf of
Your Honor, Michael Vito, First Assistant Deputy Public Defender on behalf of Ms. Wilson. Appearing via Zoom.
Moment. All right, and if my staff can hear me, I believe I may have left this packet on my desk in chambers, so if that can just be brought out, I would appreciate it. All right, and Ms. Wilson, if you'll please state your full name and spell your last name for the record.
Kamani Wilson, Wilson.
Thank you very much. Did you hear and did you understand the detention hearing rights that the court read earlier this morning?
Yes.
The court will now proceed with the motion for pretrial detention. And will review the defendant's eligibility for pretrial detention. The court will allow the state to enter the certification in support of pretrial detention and evidence as S1. Any objection by defense counsel?
No objection, Your Honor.
S1 is admitted into evidence. This court has reviewed e-courts and S1 and finds the motion for pretrial detention has been properly filed in this matter. Based upon the certification regarding the eligibility for defendant's pretrial detention, the state has asserted that the defendant is charged with a crime and there is a serious risk that the defendant will not appear in court as required. The defendant will pose a danger to any other person or the community, and or the defendant will obstruct or attempt to obstruct justice or threaten, injure, or intimidate, attempt to threaten, injure, or intimidate a prospective witness or juror. This court finds that eligibility for pretrial detention has been established based upon the reasons set forth in S1. What grounds does the state rely upon for the defendant's pretrial detention?
Thank you, Your Honor. The state would rely upon the reasons set forth in the certification.
The court will now proceed to probable cause. What does the state rely upon to establish probable cause?
Thank you, Your Honor. The state would move into evidence S3, the complaint, S4, the search warrant certification, as well as S5, which are photographs in connection with this case, and we would rely upon those to establish probable cause.
All right. Does defense counsel have any objection to S3, S4, or S5?
Your Honor, we do not have objection, and we stipulate to probable cause for the purposes of this proceeding only.
S3, 4, and 5 are admitted into evidence. This court has reviewed those exhibits and finds for purposes of this hearing only that probable cause has been established. However, there is a rebuttable presumption against detention. The court will first hear from the state regarding its arguments in support of.
I know this is all dry and boring legal stuff right now, but wait, just wait.
Pretrial detention. I will then hear from defense counsel regarding defendant's arguments in favor of release. What exhibits does the state rely upon in support of its motion to detain?
Thank you, Your Honor. In addition to everything that's already been submitted, the state would also submit S2, the PSA, and S6, the CCH.
Any objection to S2 or S6 by defense counsel?
No, Your Honor. Thank you.
They are admitted into evidence. The state may proceed with its argument when it's ready.
Thank you, Your Honor. Beginning with S2, the PSA, this defendant scored a 1 on the failure to appear scale and a 1 on the new criminal activity scale. There is no new violent criminal activity flag raised, and there is a release recommendation. Your Honor, the defendant is before you on 5 current charges, including first-degree manufacturing, second-degree conspiracy to manufacture, third-degree manufacturing, third-degree possession of CDS, and disorderly persons paraphernalia charges. Moving to the facts and circumstances of this case, throughout the months of January through March of 2024, There was an ongoing investigation into CDS distribution activities in Ocean County. A CW informed officers that they have observed a Black male known as Max Boy, who was later identified to be the co-defendant in this matter, Kyrie Kennedy, and believed that he was in possession of firearms and believed to be a gang member. They also stated that that co-defendant Kyrie Kennedy distributes heroin by the brick. Multiple buys were conducted, which yielded suspect heroin or fentanyl. And at the second buy, Kyrie Kennedy was observed making several short-term stops at various areas, including 417 Cedar Bridge Avenue, and entering the door marked 106, which was listed as being rented by this defendant, Kamani Wilson. Later found was that this Kamani Wilson was evicted from that location, but that the renter of the apartment 110 in the same complex appears to be one of her relatives, and the investigation continued, showing yes activity out of that area and that apartment as well. Additionally, surveillance was conducted at 106 and 108 Martin Luther King Drive in Lakewood as part of the investigation. And during one event, Kamani Wilson was an operator of a motor vehicle in which a prearranged buy with Kyrie Kennedy was arranged and executed. Officers again arranged additional buys. And there was one instance where Kyrie Kennedy stated that he was out, and officers surveilled him and observed to be what appeared to be the defendant restocking his supply and contacting the CW to inform him that Kennedy was now in possession of what was requested. Your Honor, throughout the investigation, Strike Force purchased one semi-automatic handgun, 58 bricks of heroin or fentanyl, which was noted to be approximately 2,900 single doses of heroin or fentanyl. When the search warrant was executed at various locations in 417 Cedar Bridge Avenue, apartment 10, again, where the officers observed the co-defendant Kennedy and this defendant, as well as a 4-year-old child exiting that apartment, was recovered 146 bricks of heroin, a quantity of marijuana, and $2,874. At 1323 River Avenue, apartment B, was recovered cocaine, magazines for a firearm silencer, and approximately 43 rounds of ammunition, as well as an additional $3,805. Additionally, there was a Charger vehicle that was used by the defendant Kennedy and registered to another co-defendant, Shakira Hill. And in that vehicle was also recovered a quantity of heroin stamped the same as was located in the search of 108 Martin Luther King Road. Your Honor, there are clear and evident concerns for the safety of the community here. The CDS distribution and the sheer amount that was recovered throughout the course of this investigation, as previously noted, was over 2,900 individual doses of heroin or fentanyl. This defendant was observed with a child in the location where there was, again, those significant amount of CDS, the 146 bricks that were recovered, and was seen engaging in CDS transaction and assisting the co-defendant Kyrie Kennedy in many of those transactions. Again, the defendant is now charged with a first and second degree offense, is facing heightened exposure and the presumption of incarceration if she is convicted of those offenses. And again, the state is concerned that this behavior will continue if the defendant were to be released at this time. The circumstances of this offense and the amount of CDS that was being circumvented throughout the community is extremely concerning, and the state does believe that this defendant poses a significant risk to the safety of the community if she is to be released at this time. It is for these reasons, Your Honor, that the state is respectfully requesting that this defendant remain detained pending trial. Thank you.
Thank you. I just want to clarify a few things, make sure I heard you correctly.
Thank you.
Is the state arguing that this defendant was driving or transporting the co-defendant Kyrie Kennedy?
Yes, Your Honor, there was one instance in which this defendant was driving the co-defendant Kyrie Kennedy.
Judge, I would ask which incident that is, because on page 21 of the certification, where it indicates that it should be noted that detectives were advised by Washington Square Apartment Management that, strike that, that it says additionally, Detective Sergeant Scrow observed Kennedy to be accompanied by Kamani Wilson. The sentence before that talks about him re-entering the driver's door of the Dodge Charger. I don't see her listed in any of these other 25 pages and 147 entries of surveillance as being an individual who was operating a motor vehicle during any of these particular alleged narcotics transactions.
Does the state have a response to that? Because this court's review of the exhibits seems to comport with the defendant's recollection and representation.
If you could just give me one moment, Your Honor, I apologize.
And it may be that counsel and the court are just overlooking it, but so if you could just point us to the page, I'd appreciate it.
Absolutely, just one moment.
You can't find it. Nothing.
I'm just looking for Your Honor, just one moment.
Oh, actually, I'm looking page 15 at the bottom. It indicates that the operator of the Honda is this defendant. So I do see that.
Honda wasn't even the heart of it.
Are there any other references other than the one at the bottom of page 15?
Your Honor, I believe that is the instance that I was referring to.
And does that answer the defense counsel's question?
Yes, Your Honor. I see on page 15 what you're talking about. I just had heard from the state, though, they talked mostly about the Dodge Charger that's not even registered to my client, and I don't believe she was operating. But I believe alleged by the state is the motor vehicle that's used in the majority of these predetermined buys.
Great, thank you. All right, so the other question I have for the state. Reference was made to the 146 bricks of heroin, along with other items, which the state has noted equals approximately 2,900 single doses of fentanyl heroin. That was located at the residence identified as this defendant's residence?
Your Honor, it's my understanding that it is a residence of this defendant's relative. So the defendant was living in the same area at a different apartment and was evicted from that apartment specifically. However, there was a relative living in the same area. This defendant was seen frequenting that area and going in and out of that apartment, again, at times with a child as well.
Okay, and that's the apartment 110 of the Washington Square Apartments, and the other apartment where the defendant was evicted from was apartment 108. I mean, sorry, of the Washington Square.
Yes, Your Honor.
And the photographs that were to evidence. Do we know, because it appears that there were several residences involved in the execution of the search warrant, Do we know which photographs correspond to which residents?
Your Honor, I'm not 100% certain. I know some of them are marked. I believe a majority of the photographs are for the residents at 1323 River Avenue. That's my understanding of it. Again, I'm not positive as to any other photographs taken at any other residences.
And I do see that 1323 River Apartment B, Lakewood, New Jersey is identified on the top of some of the pages containing the photos. It looks like it's cut off from other pages, but from the bottom part that is legible, it appears that it is also 1323 River Avenue.
And that is my understanding as well, Your Honor.
Thank you. All right, those are all the questions that I have for the state. Attorney Vito, the state has raised its concerns and its arguments in support of their request to detain the defendant pending trial. I will now hear from defense counsel regarding defendant's arguments in favor of release.
Thank you, Your Honor. May it please the court. I had the ability to meet with Miss Wilson in the Ocean County Jail last week regarding her PSA and her packet as to the contents that I had at that particular time. As I was aware, Miss Wilson is presumed innocent on these charges, and the presumption for pretrial release on this matter remains. Miss Wilson's PSA score is a 1 regarding FTA and a 1 regarding new criminal activity with no criminal activity flag raised. This is the lowest possible score for this particular risk assessment tool. The PSA is recommending the court release Miss Wilson on her own recognizance. As the court's aware, the PSA is really meant to be a tool and certainly not to replace the discretion of Your Honor to find release with conditions or releasing her on her own recognizance. However, in this instant case, the defense is asking that you give the PSA strong consideration based on the lack of criminal history and ties to the community that are substantial that Ms. Wilson demonstrates. Ms. Wilson's 26 years old and has resided in Ocean County, New Jersey her entire life. She is not currently on probation or parole. She's never been on pretrial monitoring. She has absolutely no charges that I'm aware of that are pending. She was previously residing on her own at 417 Cedar Bridge Avenue apartment, I believe 106, but recently moved in with her mother, Marcelle Griffin, in apartment 110. If released, she would be able to live with her mother at that residence in 110, or in the alternative, if the court required, she could reside with her grandmother, Marcia Griffin, at 38 Gabriella Circle in Manchester, New Jersey. As I indicated, she has substantial ties to the community, namely she has her mother, child, grandmother, 2 uncles, and an aunt in New Jersey. Miss Wilson graduated from Lakewood High School in 2015 and went on to trade school, namely Paul Mitchell School, Jersey Shore region. She's a hairstylist by trade. She asserts that she does not have any mental health or substance abuse treatment in the past. Also, it's important to note that Ms. Wilson has no prior indictable matters, no prior violent matters, DP or DV related matters. She has none, and she's never spent any time incarcerated other than the time that she spent from this particular arrest, her first arrest. The defense argues that the state has not demonstrated any articulable facts, evidence that Ms. Wilson would not appear for court, nothing that she would obstruct justice, threaten or injure any witnesses to be a danger to the community at large. I spoke briefly about what the state has put forth in their certification, and that there's within the 28 pages from Detective Grant's certification, she's referenced just briefly, I think 3 times. One time they indicate that they presume that they're speaking to her at 110 apartment on March 26th. They're not actually sure with the way that language is. That's on page 23. I already spoke to Your Honor about page 21, where it talks about her allegedly being in the car with Mr. Kennedy. Well, he's the operator of the Dodge Charge. And then Your Honor pointed out on 15 that the alleged different vehicle, a Honda, that She's the operator on that vehicle during that particular week in February of 2024. She's obviously not the prime target of this narcotics investigation. And there's nothing to demonstrate that she was involved with the actual narcotics transactions that were going on with the CW or anyone else in this particular matter. There's 147 entries of surveillance that are outlined at the end of the certification, and none of them directly indicate anything about Miss Wilson or talk about her directly. There's been no facts really to demonstrate that Miss Wilson tried to destroy any of the alleged items seized from the location during the search warrant. The state hasn't really provided any evidence to the defense that Miss Wilson was non-compliant with law enforcement during the search warrant or subsequent arrest. And if released, Miss Wilson would comply with any and all conditions that the court would impose on her. The defense respectfully argues that there are conditions available to this court that can be imposed to ensure the preservation of the triad, and that Miss Wilson will appear in court, not obstruct the judicial process, and ensure the safety of the community. With that, we submit, Judge.
Thank you very much. All right, this court is ready to issue its decision. This matter is before the court on the state's application for the defendant's pretrial detention. The court has considered the exhibits marked into evidence as well as the arguments of counsel. The defendant has been charged with first-degree manufacturing, distribution, possession with intent to distribute heroin, cocaine, second-degree conspiracy, third-degree manufacturing, distribution, possession with intent to distribute marijuana, third-degree possession of CBS or its analog, Schedule 1, 2, 3, 4, and disorderly persons, drug paraphernalia. The state has argued that pretrial detention is appropriate in this matter. In part, based upon what the state has argued is the weight and sufficiency of the evidence to date, and that approximately 146 bricks of heroin, as well as a quantity of marijuana, were located at a residence where the defendant previously resided or was evicted from. Also, that the defendant was seen in a motor vehicle driving the person to be the target of the investigation, Tyree, and also that the the defendant had a child in the location where a significant amount of CBS was, and where persons are observed engaging in CDS transactions. The state also notes that this arrest resulted after a approximate 3-month-long investigation into a CDS distribution in the area, involving significant quantity of CDS, including heroin and cocaine and fentanyl. However, this court does not find by clear and convincing evidence that no amount of monetary bail, non-monetary conditions, or combination of both would reasonably assure the eligible defendant's appearance in court when required, the protection of the safety of any other person or the community, or that the eligible defendant will not obstruct or attempt to obstruct the criminal justice process. And the court will deny the state's motion to detain. I make this denial based upon the following.
Yes.
First, this court is guided by the cases of State versus SN and State versus Mercedes. And even though the charges concern first-degree manufacturing, distribution of heroin, cocaine, this court notes that this particular defendant's involvement is referenced just a few times in the extensive search warrant affidavit. Further, this court gave heavy weight to the PSA recommendation of release on own recognizance, that the defendant has no criminal history, is on pretrial monitoring, no pending charges at the time of the offense, no prior disorderly persons convictions, no prior indictable convictions, no prior violent convictions, no failures forever, no incarcerations for 14 days or more, is not on probation, is not on parole. This court notes that the only history other than these charges is that the defendant was arrested in 2014 on CDS-related third-degree charges. However, those charges were ultimately dismissed. Court also gave heavy weight to the fact that the defendant has ties to the community. She has been a resident of Ocean County her entire life, has mother, grandmother, a child, uncles, and other relatives in the area. That the defendant is a graduate of Lakewood High School from 2015 and is employed as a hairstylist after engaging in vocational training through Paul Mitchell School. Also, this court gave heavy weight to the fact that the defendant may reside at a residence that is separate and apart from the area that was the target of the investigation. In particular, that the defendant may reside with her grandmother at 38 Gabriella Circle in Manchester, New Jersey. The defendant shall be released subject to the following conditions. The defendant will be released on level 3 pretrial monitoring conditions. This represents an upward departure from the PSA recommendation of release on own recognizance. I make this upward departure for the following reasons. The defendant was located in the area where it is alleged that significant CDS transactions and quantity of CDS was located. In particular, the residence which she resided in with her child, which the court notes she was ultimately evicted from, contained a significant quantity of both heroin, fentanyl, and marijuana, including 146 bricks of heroin. This court also makes the departure because if convicted of the second-degree charges, the defendant could be facing up to 10 years, and if convicted on the first-degree charge, could be facing up to 20 years in state prison. The defendant shall be released subject to the following additional conditions. The defendant shall appear for all scheduled court proceedings. The defendant shall immediately notify pretrial services staff of any change in address, telephone number, or other contact information. The defendant shall not commit any offense during the period of release. The defendant shall report to pretrial services once every telephone and once every other week in person. The defendant shall not leave the country without written approval from a judge having jurisdiction over this matter. The defendant shall refrain from possessing a firearm, destructive device, or other dangerous weapon. The defendant shall refrain from excessive use of alcohol or any use of a narcotic drug or controlled substance without a prescription by a licensed physician. The defendant shall avoid all contact with the co-defendants. Those co-defendants have been identified as Tamir Bergstrom, Taekwon Jones, Miguel Gonzalez, Shakiria Hill, and Kyrie Kennedy. This means no contact of any kind, no in-person, mail, electronic, telephonic, or other contact. Further, the defendant shall not have caused any other person to have contact or engage in contact with those co-defendants on behalf of this defendant. Any response or comment regarding the release conditions by the state?
I have a
Your
lot
Honor,
of comments.
just for clarity of the record, those 146 bricks of heroin that were found, they were not found in the apartment that the defendant was evicted from. They were actually found in the apartment where the defendant was residing with her mother at the time that the search warrant was executed. Just for clarity of the record, but nothing further.
Thank you for that clarification. That further solidifies the court's requirement that the defendant reside at the Manchester address and not return to the address with her mother. Any response or comment regarding the release conditions, Attorney Vito?
Your Honor, just with the last part of the requirement, I'm just not aware if for some reason my client needs to return to see her mother for some reason, if that's not allowed, in the sense, I understand she can't live there and she understands she can't have contact with the co-defendants. But if there was, for some reason, she needed to see her mother at her residence, would that be allowed, or will her mother have to see her in a different location?
I just want to verify the court's understanding. Are any of the co-defendants this defendant's, Ms. Wilson's mother?
Not that I'm aware of.
Right. So there is nothing in this court's order that will prohibit the defendant, but she just cannot reside.
Thank you. Yeah, there was an audio glitch. Did Your Honor indicate that she could visit her mother if she needed to, but cannot
Yes.
reside there? Thank you.
That is correct.
Okay, thank you.
All right. The defendant's next court date is May 13th, 2024, before Judge Rayhill, and that is here at the Ocean County Courthouse at 8:45 a.m.
That's too early.
Ms. Wilson, when you are processed for release today, you will be provided with a copy of the release order, which will include the release conditions. However, the court stated those on the record. Did you understand them and will you comply with them?
Yes.
The last page of the release order will have the contact information for pretrial services. Immediately upon your release, but no later than tomorrow, between the hours of 11:30 a.m. and 4 p.m., you must telephone pretrial services. Pretrial services takes reporting very seriously, so you must as well. The last page of the release order will also have your next court date, which I just advised you is May 13th at 8:45 a.m. It is extremely important that you do not miss that court date. If you do not appear before Judge Rayhill on May 13th, then a bench warrant will issue for your arrest. All right. Please provide us the address where you'll be residing upon your release.
38 Gap.
Thank you. And what telephone number will you be using upon your release? To receive text messages.
Yes.
All right, thank you very much. Is there anything further regarding this matter from the state?
No, Your Honor, thank you.
Anything further from defense counsel?
No, Your Honor, thank you. Just as long as Ms. Wilson knows that our office will assign an attorney to her in the near future for the balance of her matter. Thank you.
This will conclude the matter of state versus County Wilson, or Ms. Kamani Wilson. Ms. Wilson, you're free to leave the room and await processing for release.
I don't know what she needs an attorney for the future. If that wasn't enough to keep her in, yeah, they're not going to do anything. Okay, so we don't know what she did. You know, the undercovers purchased a lot of guns and heroin from the guy, but he never purchased anything from her. But come on, she's there with her kid. But she's out now. She got out yesterday because this was from yesterday. So, you know, she's still selling. There's one huge thing that I'm very upset with this courtroom about, though. Very, very, very upset. So much so that I feel like writing a letter. You could barely hear the New Jersey accents at all. Where were they? Where were our New Jersey accents? You know? That's what I came for. That's all I wanted to hear. The public defender, oh, she's not in this case, in the last case, had a tiny little New Jersey accent. But I thought they were house bricks, Your Honor. Carolyn, that'd be one freaking expensive house. God forbid it ever caught fire. And just so you know, we haven't seen Mia Mina in chat because she's been sick. So, poor Mia, I hope she's feeling better today. I wonder where Kelly is. She's going to be mad. All right. All right, this last one that I have for today is it's funny. Here we go.
69 01D012106 CM213 and 01D012104 CM119. In cases ending in 377 and as well as 119, we're here simply on hearings. There was failures to appear in those cases. And but in cases in 213, 169, and 155, we're here for initial hearings in all three of those cases. Mr. Gase, please raise your right hand. You swear or affirm under penalties of perjury, the evidence you shall give in the case now in hearing should be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Please state your full name and spell your last name, sir.
Pardon?
Please state your full name and then spell your last name.
David Allen Gase. My last name Gase.
Okay. And sir, what's your date of birth?
January 20.
All right. And are you under the influence of any drugs or alcohol at this time?
Pardon?
Are you under the influence of any drugs or alcohol at this time?
Not the drugs, sir. No.
Okay. And, what's the highest level of education that you've completed?
GED and a year of college.
Okay, good. And I had a Decatur address here for you for one of these cases, but I also saw Van Wert address. What's your current mailing address?
1254 South Shannon Street, apartment 227, Van Wert, Ohio, 45891.
Okay. And do you have an email address, sir?
I think it's,
And the reason I'm going to ask is because
I'm not really sure, Your Honor. I'm not really electronically smart.
Okay, we're not going to put an email address down because I don't want the correspondence to go to an email address that you don't use. So do you have a cell phone number that you use?
Yes, sir.
What's that?
It's,
So you'll receive text message reminders regarding hearings to that cell phone number, so you know when those are. Prior to going on record in your case, I explained your constitutional rights. Did you hear me explain them?
pardon, I mean.
Did you hear me explain your constitutional rights earlier?
Yes, sir. Yes, sir. Yes, sir.
Do you have any questions about them?
No.
No? Okay. All right, so then I'm going to go down these cases here. I'm going to first deal with the ones that we're not here on initial hearings on. So that's in case ending in 377. Also, Mr. Chad Thurston is present for the state. He appears via WebEx here in court. This hearing is being broadcast on the Supreme Court's website. Recording of it is prohibited. On the violation of informal probation in case ending in 377, let's see, we'll have an initial hearing on that case here first. And so, Mr. Gase, the violation that was filed back in 2021, in April 2021, almost 3 years ago now. And it alleges that on October 21st, 2020, that you were sentenced to 180 days of informal probation. As a condition of your informal probation, you were ordered to obey all state and federal laws which carry a criminal penalty. And then it also alleges on April 9th, 2021, that you were arrested for invasion of privacy in case ending in 119. And so that's the case, obviously one of the ones that we're not here on the initial hearing on, but that essentially alleges a violation of probation for the new case, and the court intends to have that case trail the 119, the new case as well. Do you understand that?
No, sir, I don't.
Sure. So what I'm telling you here today, just with regards to the procedures, okay, so the the violation of, the state is alleging you were on informal non-reporting probation. As a condition of that probation, you were not to violate the law or to be charged with a violation of the law. And then in case ending in 119, which I'm about to review with you here, that the state is alleging that you were in fact charged with a new violation of the law of invasion of privacy. And that's what triggered the violation in case ending in 377. Does that make sense?
No, I don't even know what I did.
Okay. So as I explained to you, you were on informal probation in case ending in 377. So in case ending in 377, that was a, let me get into it here.
I was told on.
That was a case for criminal mischief. So case 377 is criminal mischief. You were sentenced on that case. You were given informal non-reporting probation. There were conditions of that probation, of that informal non-reporting probation. One of those conditions, which I'll read to you in just a second, said that you could not have any new charges. Let me see here. Let me get it for you.
Your Honor, I was never sentenced for anything.
Sir, in case ending in 377, there's a sentencing order in this case. You were sentenced on October 21st of 2020 to criminal mischief, and it was a plea agreement that you filed with the court at that time. And that plea agreement was accepted, and you were given informal non-reporting probation. And the condition of that informal non-reporting probation, number 16, was that you shall obey all state and federal laws which carry a criminal penalty. And then number 17, if at any time while you're on informal probation, you're questioned by a law enforcement officer, arrested or cited for infraction or ordinance violation, or otherwise become involved in a civil lawsuit, you are required to notify the court within 24 hours. And so that's what you're alleged to have done with then case ending in 119, which is a invasion of privacy case. And so we'll go right into that.
I don't know what I did.
Right, and I'm about to get into that one with you too. We had a initial hearing on case ending in 119 already, and that initial hearing was held 3 years ago on April 13th, 2021. And that was an allegation of invasion of privacy, and that's what triggered the violation of probation in case ending in 377. So those are your two oldest cases.
I don't understand what invasion of privacy that I'm accused of.
Right, and so I'll read that to you again since it's been 3 years, okay? So that invasion of privacy, which triggered the violation of probation, of informal probation, that allegation, and we're not going to go through the whole initial hearing because we've already done that, but that violation alleges that on April 8th, 2021, in Adams County, state of Indiana, that you did knowingly or intentionally violate an ex parte protective order issued under Indiana Code 34-26-5 by the Adams Superior Court of Adams County under cause number 01D012012PO78 to protect Terry Roush. So that's the allegation in 119 that triggered the violation of probation in case ending in 377. Do you understand that now?
Well, I understand that, Your Honor, but her and I have been reconciled since then.
Okay, so that still is a violation of invasion of privacy. The reconciliation, that may be a defense, but regardless, that invasion of privacy is that a new case. We already had the initial hearing on that, so we won't go through that again. So we're here on there was a failure to appear for a hearing in that case, in case ending in 119. So in case ending in 119, the court, you're currently on a no bond failure to appear status. You now have appeared, and so the court is going to set bond in case ending in 119, and that's going to be for $525 cash and $6,000 surety, and that's in case ending in 119. All right, now case ending in 377, I'm going to have that trail case ending in 119. And so you're currently on a no bond status for that violation of probation in case ending in 377. All right, so now the newer cases, sir, let's get to those here. So case ending in 155. Now that is a new offense. We haven't had the initial hearing here on it this morning. So you were charged by information filed in this court in case ending in 155 with invasion of privacy, a Class A misdemeanor. And that alleges that on or about May 3rd, 2021 in Adams County, state of Indiana, that you did knowingly or intentionally violate an ex parte protective order issued under Indiana Code 34-26-5 by the Superior Court of Adams County under cause number 01D012012PO78 to protect Terry Roush. So that case ending in 155 alleges the same violation of the same protective order as 119. Do you understand that?
No, I know, I really don't, Your Honor.
Which part of that don't you understand, sir?
How I violated protection.
Protective order, so
I
that's
didn't
what
do
the
anything I didn't do anything to no one.
So, Mr. Gase, you could have a whole number of defenses. You are presumed innocent, but at this time, that's what the state is alleging that you've done. They're claiming that you violated that protective order that protected Terry Roush. Do you understand that?
I don't know what I did.
All right. Well, they're alleging that you violated a protective order. Now, that's all that they're alleging that you've done. You understand what they're alleging you've done, correct?
Yes, sir.
Okay, so invasion of privacy, that's a crime under Indiana Code 35-46-1-15.1. Now, that statute states that a person who knowingly or intentionally violates an ex parte protective order issued under Indiana Code 34-26-5 commits invasion of privacy, and that's a Class A misdemeanor. Do you understand how the law is defined as I just explained it to you?
No, sir, I don't.
All right, I'll read it to you again.
I don't understand any of this, Your Honor.
All right. Oh, fair enough. So, let me read it to you again, and I'll read you the statute one more time. Invasion of privacy under Indiana Code 35-46-1-15.1 states that a person who knowingly or intentionally violates an ex parte protective order issued under Indiana Code 34-26-5 commits invasion of privacy, and that's a Class A misdemeanor. Do you understand the law as I just read it to you?
Well, Your Honor, the only thing I understand is, that I had 3 missed calls and I never even spoke to her.
Okay. Do you understand the law as I just explained it to you?
Well, I understand what you're saying, but I don't understand what I did.
Right. And so that's something that we'll get into later. For this initial hearing, I just want to make sure you understand what they're alleging that you've done and what that statute is. Does that make sense? Okay.
That part.
Fair enough. Okay. So in case in 155 then, that alleges a Class A misdemeanor. Class A misdemeanors, all of them in the state of Indiana, carry with them the potential penalty of 0 to 365 days in jail and a $5,000 fine. You understand that, correct? The potential penalties for Class A misdemeanors?
She's married now. I don't understand any of this.
All right, thank you for that. But my question was, do you understand that Class A misdemeanors in the state of Indiana carry with them the potential penalty of 0 to 365 days in jail and a $5,000 fine? Okay. Now, case ending 155, the court intends to set a bond in accordance with the presumptive bond schedule in that case as well. That's $525 cash and $6,000 surety. That'll be for case ending in 155. Now, when we move on to case ending in 169, in case ending in 169, there's 2 allegations in case ending in 169. Count 1 is invasion of privacy, a Class A misdemeanor. Count 2 is harassment, a B misdemeanor. Count 1 reads that on or about May 14th, 2021 in Adams County, state of Indiana, that you did knowingly violate a protective order to prevent harassment issued under Indiana Code 34-26-5 by the Superior Court of Adams County under cause number 01D01 2102 CM 155 to protect Terry Roush. Do you understand how that count reads, Mr. Gase?
No, I don't.
All right, I'll read it to you again. So that
I
what the
can't
state is.
comprehend that for anything.
All right, what the state is alleging that you've done in this case in 169 and under count 1 is that on or about May 14th, 2021 in Adams County, state of Indiana, that you did knowingly violate a protective order to prevent harassment under Indiana Code 34-26-5 by the Superior Court of Adams County under cause number 01D01 2102 CM 155. That's the case I just previously read, that there was a protective order issued under that case to protect Terry Roush. Do you understand what you're alleged to have committed in count 1 of this case?
It was just,
What's that, sir?
as I guess, I
Okay.
understand what you're saying, I don't understand the charges.
All right, well, I've read to you what you're alleged to have committed in count 1. Now, count 2 is states that on or about May 14th, 2021 in Adams County, state of Indiana, that you with the intent to harass, annoy, or alarm Terry Roush, but with no intent of legitimate communication, did make a telephone call to it 5 calls from the defendant. Do you understand what the state is alleging have you done in count 2?
I never even called or talked to her.
I understand you can have a defense to that, sir, and you are presumed innocent. The state is alleging that you've made 5 calls to her that violated, well, that constituted harassment under the law. Do you understand that?
I understand you're charging me for something that didn't happen.
Okay, fair enough that they're charging you with it. All right, so that alleges a violation of Indiana Code 35-45-2-2. Now, that statute states that a person who with intent to harass, annoy, or alarm another person, but with no intent of legitimate communication, communicates with a person by telephone, mail, or other form of written communication, commits harassment, a B misdemeanor. Do you understand how that law is defined as I just read it to you?
I don't understand any of this.
Mr. Gase, do you understand the law as I just read it to you?
I heard what you said.
Okay. All right, so that's an A misdemeanor and a B misdemeanor. The A misdemeanor carries with it the potential penalty of 0 to 365 days in jail and a $5,000 fine. The B misdemeanor carries with it the potential penalty of 0 to 180 days in jail and a $1,000 fine. Do you understand the potential penalties you face for those 2 offenses, sir? Mr. Gase, do you understand that?
Yes, sir.
Okay. Now, for case ending in 169 with regards to bond, the court intends to set bond at $525 cash and $6,000 surety.
Can I ask a question?
Go ahead, sir.
Are you charging me $500 for each thing?
I'm sorry?
Are you charging me $500 bond for each one?
Well, in 119, 155, and 169 so far, correct. That's $525 cash and $6,000 surety in each one. And then 377 is no bond. That's a violation of probation. So that's a no bond status. So we have one more here still to go here. And that is case ending in 213. And so for case ending in 213, you're alleged to have committed a failure to appear, a Class A misdemeanor. Now, that states that on or about June 9th, 2021 in Adams County, state of Indiana, that you, having been released from lawful detention on the condition that you appear in Adams Superior Court on May 12th, 2021 at 11 a.m., in connection with the charge of a crime, to wit, invasion of privacy, did intentionally fail to appear at said time and place. So that's a failure to appear offense that the state's alleging that you've committed. Do you understand that?
Yes, sir. I contacted my probation officer. I contacted that coronavirus. I was stuck in Ohio with no way to get here.
Okay.
And I explained that to my probation officer, and
So like I said before, that can be a defense in the case, and you could have a lot of defenses. You're presumed to be innocent, but right now the state's alleging that you committed that offense. Do you understand that? You understand that, Mr. Gase?
yes, sir.
All right. That alleges a violation of Indiana Code 35-44.1-2-9, and that statute states that a person who, having been released from lawful detention on the condition that the person appear at a specified time and place in connection with the charge of a crime, intentionally fails to appear at the time and place, commits failure to appear, and that's a Class A misdemeanor. You understand how the law is defined under that count, sir? You understand? Mr. Gase, do you understand how the law is defined under that count?
I don't comprehend all
Okay, I'll read it to you again. Indiana Code 35-44.1-2-9 states that a person who, having been released from lawful detention on the condition that the person appear at a specified time and place in connection with the charge of a crime, intentionally fails to appear at the time and place, commits failure to appear, a Class A misdemeanor. You understand how the law is defined under that count, sir?
that. I ain't have no way.
I understand you could have a defense, but do you understand how the law is defined?
I understand it.
All right. So that alleges a Class A misdemeanor. All Class A misdemeanors in the state of Indiana carry within the potential penalty of 0 to 365 days in jail and a $5,000 fine, just like the other Class A misdemeanors you're alleged to have committed. Do you understand that, sir? What's that? All right, I'm going to take it that you understand that because you understood it earlier here today. So with regards to case ending at 213, I'm not going to set the $525 cash. I'm going to set it in accordance with the presented bond schedule for $300 cash and $4,500 surety for case ending in 213. So we set those bonds. You're a United States citizen, right, sir? Mr. Gase, you're a U.S. citizen, correct? All right. Mr. Gase is not being responsive here to the court. Mr. Gase, with regards
I
to...
understand you have to.
Okay. Would you like
Distraught by all this.
All right, sir. I understand it can be a stressful situation.
No crime.
With regards to...
One.
All right. With regards to an attorney, would you like the public defender to represent you, Mr. Gase?
Yes, sir.
All right, the court's going to appoint the public defender to represent Mr. Gase in all 5 cases. We're going to set this for an attorney pretrial conference for I'm going to take reimbursement under advisement with regards to the PD. Attorney pretrial conference, Mr. Thurston.
Judge, can we have April 30th at 1 p.m., please?
April 30th at 1 p.m. and then we'll have an omnibus date for
June 10th.
June 10th, 2024. Mr. Gase, you'd like to speak with the public defender before setting the trial date in these cases, correct?
Pardon?
So the omnibus date is typically the trial date. And so rather than setting the trial date on the omnibus date as the statute requires, if you would like additional time to speak to your attorney prior to setting that date on the omnibus date, I'll grant that to you. Would you like?
I'd like to have you tell me I'm locked up now forever.
Wait, what now? What'd you say? I didn't quite hear you.
I'm locked up now forever for this.
No, that's not what I said. I set bond in the case, and then I'm asking you regarding the omnibus date, if you want that to be on the trial date. Would you like to speak with your attorney before making that decision?
Yes, sir.
Okay, I'll grant that request. So we'll have that omnibus date on June 10th, the attorney pretrial conference on April 30th. You can contact the public defender's office through the jail portal there in the event you're still in jail. Otherwise, I've set the bond in those 5 cases, and with the exception of 377, which is that violation of probation is at no bond status. Mr. Thurston, anything to add to that?
So in other words, I can't get out.
No, Your Honor, thank you.
All right. I'm not saying that, sir. I set the bond in this case, and you'll have to talk to your attorney if you want that to be reviewed. And otherwise, well, with regards to the 377, if you want that no bond status to be reviewed, you can file a request to review that at that time.
That's why my question is, I can't even get out at all. Right?
Correct. Currently, because a 377 is a violation of probation, and that's a no bond status. You're correct about that until that's reviewed or changed.
I can't get out whether I pay that much money or not.
Correct. Until that change, until 377 is changed, if you went and paid all the bond and at that time, you still wouldn't be released. You're accurate.
Yeah, I can't pay
That's all we have. This hearing is concluded. All right, Ms. Washington, we're now on your case.
Sorry, I was saying hello to two people in chat real quick. We made it. He made it to the end of that. I didn't think we were ever going to see the end of that, and we did. Oh, man. That's Indiana, guys. That's Indiana. What a difference from Texas. What a difference from Jersey. Oh, man. Oh, thanks for coming out today, guys. B24, I hope you're having a good day. Kelly, I'm sorry you missed it. She's going to be mad. I hope she's okay. I hope she's not sick. All right, guys, that's what I have for today. Oh, wow. It's late, guys. We have court's about to start any minute now. I'm excited. I don't know what we're going to see today, but I'm so excited. I feel like it's going to be good. Good. All right. I hope you guys have a great day. Thanks, Cloud. It was, Elizabeth. It was like watching paint dry. That's what it was. It was so painful. Oh, I'm just so glad he got to the end. All right, guys, behave today. Behave, and I will talk to you tomorrow. See ya.